I'm Brittany Lewis with Forbes Breaking News. Senator Richard Blumenthal defended calls to reform Supreme Court ethics and recusal rules on Tuesday. The Connecticut Democrat responded to a leaked Supreme Court decision striking down Roe v. Wade. He noted that, quote, countless American women right now are feeling afraid. Blumenthal is a pro-choice advocate and condemned the possibility of ending federal abortion rights. Here's more from Senator Blumenthal.
So I'll turn to Senator Blumenthal, but before I do, I just wanted to note that in the record is the letter from Gabe Roth that I put in at the opening of the hearing, and anybody who is interested in a list of areas of potential judicial misconduct. Obviously, it's impossible to prove because there is no body to go to with those concerns. But to answer your question, the Roth letter, I think, provides a pretty good summary. And Senator Blumenthal.
Thank you, Chairman Whitehouse and Ranking Member Kennedy for having this hearing. It's an important hearing on an important day, and there are few topics more important than the United States Supreme Court as an institution. And lest we immerse ourselves too much in the abstractions and seemingly sometimes arcane discussion of rules, we ought to keep in mind that countless American women right now, today, are feeling afraid, alone, anguished, and really angry. Why does that matter? Because the United States Supreme Court, as an institution, is nothing without credibility and trust from the American people. It has no armies, it has no police force, it has no power of the purse. And anyone who has clerked, as I have in the United States Supreme Court, is aware that the justices themselves have to keep in mind that they are stewards of an institution. So when they come before the United States Congress in their confirmation, they say, we have respect for precedent. We believe in stare decisis. And then they, in effect, say, as the draft opinion does, well, stare decisis doesn't really matter that much when it's the Constitution. It undermines fundamentally the trust and respect that the American people have for the United States Supreme Court. And nothing is more precious and more essential to its power. And once it's lost, I worry deeply that it will never be repaired. So the court as an institution, I think, is gravely in peril right now. The topic that brought us here and the reason why we scheduled this hearing obviously has to do with other issues that involve conflicts of interest and the need for a code of conduct that the Supreme Court would set itself under legislation that I've joined in co-sponsoring. I'm proud to be a supporter of the legislation led by Senator Whitehouse. But what we're dealing with here is an institution that is so rare in our American democracy. It's unelected, appointed for life, unreviewable, basically unaccountable. In a democracy where all of us are elected, the president's elected, members of local planning and zoning boards are elected, the alternates to those members are elected, in Connecticut at least. So it seems to me the Supreme Court itself ought to be in favor of this kind of basic fundamental accountability. And of course, members of the court have said, Justice Kennedy, Justice Kagan, and others have testified they are considering it. Year after year, we're considering it, but they haven't done it. Without a mechanism for accountability and without disclosure, the minimum that ought to be expected, Supreme Court justices are free to rule in cases where the public could reasonably believe they have a conflict of interest, as in owning stock in the companies that are involved in the cases before them. And this has affected justices across the board. Justices Breyer and Alito failed to recuse in Feng versus Commenda and Rockwell Collins, even though they both own shares in Rockwell's parent company, United Technologies. Justice Alito failed to recuse in Merck, Sharp, and Dome Corporation versus Albrecht, despite owning shares in Merck. Chief Justice Roberts failed to recuse in BB Inc. versus Arizona Board of Regents, despite owning shares in Texas Instrument stock, a party to the ABB side. So I could go on at some length, but let me just ask Professor Frost, do you think that this legislation can help, even now, preserve the Supreme Court's credibility?
Yes, I do. I think if you're talking about the proposed bill and the ability of the Supreme Court to come up with its own code of conduct, I think that is the best solution. What I would hope would happen as a result of hearings like this and proposed legislation like this is that the Supreme Court would wake up and take action. This bill suggests that the Supreme Court itself develop a code of conduct for itself, and as you've noted, Justice Kagan said the court was seriously considering that in 2019. So we're really just giving a nudge to the court. This will improve the operation of the court, this will improve its integrity, and take this ball and run with it. You craft a code of conduct for yourselves, and this branch of government won't interfere. We're just pushing you to go ahead and do so as you suggested you want to do yourself.
Mr. Payne, do you agree?
I do agree. I think that with the code of conduct, the justices can have clear rules and clear interpretation of those rules to improve the public's perception that they take ethics seriously and are impartial.
Thank you. My time has expired, but I appreciate, Mr. Chairman, you're having this hearing and leading this legislation. Thank you.
So, thank you for joining us, Senator Blumenthal. We've been working together on this, so your partnership is much valued. And over to you, Senator Cruz.